Ms. Simpson, are there any reporting instructions you want me to get on the record for Mr. Coleman? Sit tight, Mr. Coleman.
Yes, he has his report instructions to report to his Clayton County Probation Office on January 23rd at 8 a.m.
January 23rd at 8 a.m. at that address you've got on a piece of paper, okay?
Yes, sir.
All right, good luck.
All right, thank you.
Bye. Thank you. All right, next matter is State versus Newsom, 24 SC 004430. Mr. Newsom is represented by Ms. Merchant. Good morning.
Good morning, Judge. Good to see you.
Good to see you. Mr. Newsom is here, and there is another person up at the podium.
Judge, I'm Larry Cohn. I'm also co-counsel with Ms. Merchant on this case. KOHN, Larry Cohn.
KOHN. All right, Mr. Cohn. And we have Mr. Miller as the prosecutor. Mr. Newsom, in a moment, Mr. Miller is going to put you under oath. You may have watched what happened with the previous defendant, but it will be similar. A bunch of questions about your rights. You'll need to let us know your responses. If at any point you've got a question or you need to speak privately with Ms. Merchant and or Mr. Cohn, that's fine. Just let me know. I need to be comfortable that you are asking the questions that you have. All right? And you'll need to speak up a little louder for the court.
Sorry. Yes, Your
Okay, for
Honor.
the court reporter. All right, Mr. Miller, when you're ready.
Thank you, Your Honor. Mr. Newsom, could you please raise your right hand? You swear or affirm that the testimony you should give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth.
I do.
You may lower your hand. Mr. Newsom, please state your true and correct legal name.
Joshua Forrest Newsom,
And could you spell your first and last name for the record, please?
JOSHUANEWSOME.
Mr. Newsom, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No,
Is there a medication that you normally take that you have not been given today?
no.
Mr. Newsom, how old are you and how far did you go in school?
I'm 46 years old. I completed a Bachelor of Science in college.
And so you're able to read, write, and understand the English language.
Yes,
Ms. Newsom, do you understand you are charged with the following offenses in indictment number 24 SC 004430? You are charged with 7 counts of sexual exploitation of a minor pursuant to OCGA 16-12-100, Section B, Paragraph 5. Do you understand?
yes,
You understand that you have a right to plead guilty or not guilty to these charges. And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Mr. Newsom, have you reviewed the waiver of rights form with your attorney?
yes,
And is this your signature on the second to the last page of this document?
yes, it is.
Now, did you have enough time to speak with your lawyers about all the facts and circumstances known to you about the charges in this indictment?
Yes,
Do you need more time to discuss this case with your attorneys?
no,
Are you satisfied with their services?
yes,
Counsel, do you waive formal reading of the indictment?
Yes.
Counsel, do you waive any and all defects in the indictment, including any with respect to your client's name?
Yes, we do.
Mr. Newsom, have you been arrested on these charges?
yes,
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
no,
Mr. Newsom, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading guilty to today?
yes,
So for example, the charge of sexual exploitation of a minor, there's a sentencing range of 5 to 20 years in custody. Do you understand?
yes,
You understand that this is a negotiated plea, which means the state will recommend to the court the following sentence. For count 1, sexual exploitation of a minor, 10 years probation. Count 2, sexual exploitation of a minor, 10 years probation. Count 3, sexual exploitation of a minor, 10 years probation. Count 4, sexual exploitation of a minor, 10 years probation. Count 5, sexual exploitation of a minor, 10 years probation. Count 6, sexual exploitation of a minor, 10 years probation. And count 7, sexual exploitation of a minor, 10 years probation, with all counts to run concurrent with one another. However, the court does not have to accept this recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutive or concurrent. Do you understand?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
You understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions or probation without being subject to revocation for the balance of the sentence.
Yes.
Mr. Newsom, do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you're pleading guilty to a crime against a minor, including kidnapping, false imprisonment, or conduct of sexual nature involving a minor, or if you're pleading guilty to a dangerous sexual offense as defined by state law, you will be required to register as a sex offender?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes.
You understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections or Board of Pardons and Parole, and no one can guarantee parole no matter what anyone has told you.
Yes.
You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial. For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison.
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea today.
Yes.
You understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself.
Yes.
Do you understand that by pleading guilty, however, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand?
Yes.
Mr. Newsom, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Mr. Newsom, how do you plead to the charge count 1, sexual exploitation of a minor, in indictment number 24 SC 004430?
May I ask a question?
Yeah.
Guilty.
Mhm.
Guilty.
Mr. Newsom, how do you plead to count 2 in indictment number 24 SC 004430, the charge of sexual exploitation of a minor? How do you plead to that charge?
Guilty.
How do you plead to count 3, sexual exploitation of a minor, in indictment number 24 SC 004430?
Guilty.
How do you plead to count 4, sexual exploitation of a minor, in indictment number 24 SC 004430?
Guilty.
How do you plead to count 5, sexual exploitation of a minor, in indictment number 24 SC 004430?
Guilty.
How do you plead to count 6, sexual exploitation of a minor, in indictment number 24 SC 004430?
Guilty.
And how do you plead to count 7, sexual exploitation of a minor, in indictment number 24 SC 004430?
Guilty.
Mr. Newsom, Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you may only have a limited right to appeal this guilty plea conviction.
Yes.
You understand that you have only 4 years from today's date for a felony charge to file what is called the habeas corpus petition, challenging the constitutionality of this guilty plea.
Yes.
You understand that you have a right to withdraw the plea, but you have to do so before the term of the court expires.
Yes.
You understand that you have 30 days from the date of the sentence being entered to file a direct appeal.
Yes.
And Mr. Newsom, prior to entering this plea, what I'm showing you is a document that is labeled General Conditions of Probation. Did you go over this document with your attorneys?
Yes, I did.
And Mr. Newsom, are these your initials and is this your signature on the last page of this document?
Yes, it is.
Mr. Newsom, does your initials and your signature on the last page of this document indicate that you agree to adhere to the terms and conditions listed in this document?
Yes.
Mr. Newsom, what I'm now showing you is a document that is entitled Sex Offender Special Conditions of Probation. Did you go over this document with your attorneys?
Yes.
Now, is this your initials and is this your signature on the last page of this document?
Yes.
Does your initials and your signature on the last page of this document indicate that you agree to adhere to the terms and conditions in this document?
Yes.
Mr. Newsom, what I'm now showing you is a document that is entitled Department of Community Supervision's Restrictions for Computer Usage. Did you go over this document with your attorneys?
Yes.
Mr. Newsom, are these your initials and is this your signature on the last page of this document?
Yes.
Does your initials and your signature on the last page of this document indicate that you agree to adhere to the terms and conditions here in this document?
Yes.
And lastly, Mr. Newsom, what I'm now showing you is a document that is entitled Department of Community Supervision's Mandatory Submission to a Polygraph as Conditions of Probation. Did you go over this document with your attorneys?
Yes.
Did you have any questions regarding this document?
No.
And is this your signature on the last page of this document?
Yes.
And does your signature on the last page of this document indicate that you agree to adhere to the terms and conditions in this document?
Yes.
Thank you, Mr. Newsom.
May I ask a question? Can I talk to you for a second, if you don't mind, Your Honor? In regards to the conditions, I believe there may be one page that sounds like we may be missing out of those conditions that.
Okay, let's clear that up so we're not overlooking anything that needs to be included.
He doesn't have a curfew.
Right. That's a registered requirement.
It's not
not
a
registered.
requirement.
Yeah.
We can address that with the court at the appropriate time.
Can we keep going?
We can, Your Honor.
Okay.
Your Honor, had this case gone to trial, the state would have been able to prove beyond a reasonable doubt that on January 4th of 2022, Special Agent Haley Peacock of the Georgia Bureau of Investigations was conducting an online investigation on the BitTorrent network for offenders sharing child sex abuse material, also known as CSAM. Special Agent Peacock directed the investigative focus to a device at IP address 99.29.82.204 because it was associated with 70 torrents of interest. The subject using the IP address was observed on the BitTorrent network as being in possession of 100,000 files of interest, of which 14,000 of those files were categorized as severe files. Now, severe files are files with hash values that are known to law enforcement to depict images or video of child sex abuse material. Now, they are generally labeled as being severe because they involve sexual abuse of children. Of the 14,000 severe files, 7,000 of the files depicted abuse of children. Special Agent Peacock noted that law enforcement was running undercover tools in the Big Torrent network. Investigator Mike Duncan and investigator Jason Brooks received downloads of child sex abuse material from the targeted IP address by way of peer-to-peer sharing. According to investigator Brooks, on January the 3rd, 2022, around 10:50, he successfully completed the download of at least 11,000 pieces of torrent with info hash that indicated it was CSAM. The following is a description of 5 of the files that he was able to download from the subject's device distributed.
Are the files you're about to describe files that are charged in the indictment?
Yes.
Okay.
Yes. So the first file depicted an adult male engaging in digital penetration with a female minor child. One of the second files that was labeled Special 6 as the file name, it depicted an adult male engaging in oral to genital and genital to genital sexual intercourse with a female minor child. The third file depicted a adult male, depicted a minor female child fully nude while engaging in oral to genital and genital to genital sexual intercourse with an unknown male whose face was covered. The next file depicted female minor child engaging in genital to genital sexual intercourse with an adult male. And then the other file, the last file, depicted several female minor children engaging in genital to genital sexual intercourse with an adult male. Investigator Mike Duncan had indicated that he was also able to download files from the suspected IP address as well. Here's the description of 2 of the files that he was able to download. One file depicted an adult male engaged in oral to genital and genital to genital sexual intercourse with a female minor child. And then the other file depicted 3 prepubescent minor female children fully nude, taking turns digitally penetrating one another. On January 21st, Special Agent Peacock received a subpoena response from AT&T in reference to the subscriber information associated with the IP address that you submitted on January 4th. The subscriber information indicated as follows: the return information coming back to a Joshua Newsom at 70 Northern Court in Johns Creek, which is in Fulton County. On Tuesday, February 15th, Special Agent Peacock obtained a search warrant for the residence. And during that time, they were able to see several digital devices. However, there were several that were seized in triage for child sex abuse material that did not possess any child sex material. However, when it came to a Kindle notebook and a Dell computer, they were able to determine that the Dell computer had files that matched the files that were downloaded by the agents during the investigation. While on scene, the accused was Mirandized and the defendant did agree to speak with law enforcement. The accused admitted to viewing CSAM on the Kindle Fire and the Dell laptop. Digital forensic investigators found files indicative of child sex abuse material on the Dell computer located inside the defendant's bedroom. The defendant did state that he was the only person who used the Kindle Fire, and the Kindle Fire and the Dell laptop was seized. Your Honor, based on state's review of the file, to our understanding of the defendant's criminal history, he does not have a criminal history. Based on the investigation by Special Agent Peacock, no female minor children were injured by this defendant, nor were they transported. Given that, Your Honor, the state and defense has agreed to deviate from the sentencing guidelines listed in OCGA 1710 6.2. And because of that, the state is recommending a sentence of 10 years probation on all counts to run concurrent. It's also our understanding that as this case has been pending, the defendant has submitted to counseling as well, Your Honor, which is one of the reasons as to why the state was agreeing with the sentence that is recommended to the court at this time.
Okay, couple questions. One, if you weren't moving to deviate, what is it? Is there a mandatory minimum that involves incarceration, or what is it that is non-minimum? Because 10 years probation is more than 5. And the range you gave me was 5 to 20.
Right. So so according to 1710 6.2, he would have to at least do the minimum of, it would have to be a term. He has to do the minimum, but he also has to do at least 1 year probation. So 6 serve 5 would be the most that he could do, the lowest he could do based on the statute.
Okay, let me look something up. Okay, other question, you didn't indicate any special conditions of probation independent of the whole roster
Yes.
of the items that Mr. Newsom is signing up for. Were there any additional, or you're satisfied that the sex offender conditions of probation, and I think you had another list of conditions, that addresses whatever concerns the state has?
With the addition that the defendant, thank you, Your Honor, with the addition that the defendant continue to undergo counseling and treatment as he has been doing so as his case has been pending.
Okay, I'll need that to be a little clearer, in particular for Mr. Newsom. Is it the state's request that Mr. Newsom receive counseling all 10 years of probation, or until a expert says counseling isn't productive anymore, or is there a certain period that you're recommending Mr. Newsom continue to get counseling?
Your Honor, because this case has been pending for the past 3 years, then I would submit that it will be after the counselor has indicated that counseling is no longer needed for Mr. Newsom.
And I can provide some clarity on that maybe as to what he's been recommended for, if that helps the court.
That'll be helpful. I'll let you get to that in the
Perfect.
natural flow of your presentation. I
Okay.
just wanted to make sure there was nothing else
Wonderful.
from Mr. Miller. Thank you.
Thank you, Your Honor.
Ms. Jackson, good morning. Do you have any criminal history information on Mr. Newsom?
Your Honor, he does not have any prior arrests on file, nothing in addition.
Thank you. Okay. Ms. Merchant, I'm much more familiar with the federal statutes, and we wouldn't be talking about probation with Mr. Newsom. I don't know why the GBI took this case state rather than federal, but here we are, and we're in the state domain. I don't read 1612-100, which I'm looking at for maybe only the second time, as having a mandatory anything. So I don't know that I'm not disagreeing with Mr. Miller, but I don't know that any sentence sheet that I fill out, final disposition, needs to invoke 1710-6.2, because I think 10 years probation falls within that range of 5 to 20, and more germane to the point I'm making, I didn't find any language in 1612-100 that says it's not probatable. It's the standard. It's like aggravated assault, 1 to 20, but you could probate it. So
I agree with your reading.
okay, all right, and it doesn't change anything the state's recommending. I'm just not going to have 1710-6.2 appear on the sentencing sheet, because I wouldn't deviate on anything for Mr. Newsom. I'm not being asked to deviate. I think if you were trying to get a 2-year probated sentence, I'd need to invoke that, but it's only probation, but it's in that range. So that's where I fall on that. It doesn't change the outcome. I just want to have it be as legally accurate as possible. So Ms. Merchant, what you want to share, or Mr. Cohen, I don't mean to say you're in charge. You guys share with me what you want about Mr. Newsom and this situation.
Thank you, Judge. I just want to go over a little bit about what he has done, because I think his taking responsibility immediately for this action has led to where we are today and the recommendation from the state. He has also done a lot of treatment because he was willing to take responsibility immediately. This was a download of adult pornography that had what they ultimately found were 7 images that were child sexual abuse. There's no evidence that he was actively searching for specifically volumes of child sexual abuse, but he has freely admitted that he uses pornography and has sexually compulsive issues. He immediately sought treatment. immediately took responsibility for this. One of the reasons he's been able to do so much of the treatment, unlike a lot of clients, is he made an admission. So a lot of times we have to get a psychosexual evaluation, but we're not allowed to start treatment because there's no admission. He said, I don't even care if it can be used against me later in court. I'm going to go ahead. I need this treatment. I'm going to go ahead and make an admission. And so he did that back in 2022. He had the psychosexual evaluation by Dr. Kennel Reiner, who is a licensed psychologist, a doctor, a PhD.
Can you spell his last name for the record?
And it's Kendall, Kendall. Last name is Reiner, Reiner. And she actually did the evaluation in March of 2022. And she recommended him for treatment. At that time, she found that based on his psychosexual evaluation, he had about a 4% risk of reoffense. He had one of the factors present. She recommended him for the full 7-phase treatment plan, which is what we normally see. We don't see it this phase. It's normally later on because most people do it on probation, but he actively engaged in it. And he's actually completed 4 of those 7 phases. He's done 77 classes for that already. So he's done a lot. And she has presented us a letter. We've given it to the state, sort of updating the state as he's gone along with the treatment. But some of the things that I just wanted to highlight to the court was he takes full responsibility for his offense. He has done so since he started treatment. He has included his family in the treatment process, and his wife and his oldest son are here. He has younger children that it's not appropriate for them necessarily to be here, but they have all known about what's happening. And that's one of the things that we see with people reoffending. They're keeping it secret from people. He has not done that. He's actively owned what has happened in this case. And so because they're involved in therapy and because they've been involved in this, Dr. Reiner thinks that he is a very low risk, even further than that 4% back in 2022. She has recommended that he continue the treatment, continue aftercare, and because he's done so well, and him doing treatment is what will lead to him not having reoffense issues. That's why the state and the defense has agreed to this and thought that this was an appropriate sentence. Just want to address the one thing that the Department of Supervision had mentioned.
Yeah, before you do that.
Yeah.
Are there a bunch of documents you need to give me?
Yes, Your Honor.
Thank you. Appreciate it.
Let me add one other
Yeah.
thing. Judge, if I can just add, just so that you know a little bit about him, he's 46 years old. He has, as the state indicated, there's no criminal history. He's been married to the same woman since 1998, gainfully employed for the last 27 years, 24 with one company, 3 with another company as a software engineer. He's got 4 children, 2 of which have significant health disorders. He's the sole provider for his family. His wife also is here, who has some medical conditions as well, some immune and some, I guess, muscular issues would be the best way I can phrase that. 2 weeks after he was arrested is when he sought the evaluation, the psychosexual that Ms. Merchant mentioned. We believe that he's a terrific candidate for probation, as does the state. I would like Ms. Merchant to elaborate on the provisions the probation officer had brought up.
How old are the other kids in the household?
At this point, 15, or they're 20, I think one would be 25, one would be 20, one would be 15, and the other would be 13. So the 15 and the 13-year-old, those are the ones that reside with him at home.
16,
And the
14.
16 and 14, I'm sorry.
Time has passed.
Time has
Time has passed.
16 and 14, boys or girls?
Boys.
And the state has agreed that that will not be an issue for him to live with them. We've also already pre-court today checked with the Fulton County Sex Offender Registry. His house is sex offender compliant, so there are no issues in terms of that.
When you say his house is, not meaning it's got the right appliances,
No,
but
it
it's not near a
resides-
park, it's not
exactly.
near a church,
Its
whatever.
location is compatible with the code section.
Okay. Good thing to do. All right. So there was something about the special conditions you wanted to discuss.
Yes, I just wanted to mention it because probation had brought it up. So this, essentially, it doesn't apply in this case. Probation presented this additional condition of probation document about electronic monitoring. It says that if he is declared a sexually dangerous predator under 42-1-14, which he's not, if he is ordered by the court to wear a GPS monitoring system, then this would apply. That's not part of our negotiations. That's not something that has been discussed as part of this negotiated plea, so it wouldn't
Okay.
apply to us.
Officer Evans, I don't want to set Mr. Newsome up for failure if I exclude an ankle monitoring condition, because it doesn't seem like it quite fits in this scenario, is that going to create friction with DCS?
No, Your Honor, that's what I was gonna announce, that was only if in fact that Your Honor had ordered that, then that condition would have needed to be.
Okay, but it's good that you flagged it so there weren't surprises. He's leaving. You're like, wait, we got to put this on your ankle.
Thank you.
Yes, Your Honor.
Okay, got it. Okay. Anything else, Ms. Merchant?
No, thank you, Judge.
So, Mr. Newsome, this is a difficult situation for you. I am sure you're here in public. You're being live streamed. People are hearing about things you did that have no pleasant aspect to them. And I appreciate Ms. Merchant doing her job, which is to say, hey, there were only 7 images. It's actually not what I heard. What I heard was that there were 14,000 files. I have a little background in this space, so I get it when they talk about hashtags and severe files and this and that. And so my first observation is 100,000 files is a big old collection. But I appreciate the observation that it wasn't exclusively child exploitation material, but it's not that there were 7 out of 100,000. It's a higher percentage of that, and it's a percentage level that says to me that anyone who was even mildly curating his collection would have realized what it was. And while I appreciate Mr. Miller saying there's no evidence that you harmed anyone, consumption and distribution and trafficking is harming because it's perpetuating the victimization of those little boys and girls. And it sounds like it was mostly girls. You never laid hands on them, but you made it available to others, and it may feed their habit that is of a sexually violent nature. And I'm not telling you something you don't know. And that's the part that's too bad about this. You are a smart, successful person on many other fronts. But I will add this, I'm not condemning you. You are wired differently than some people because you were doing these things because of compulsions. That doesn't excuse it, but there's a reason why these cases are exceptional, because it's not what everyone does. And I think it's a good sign that you immediately elected to receive treatment and that you were open and honest about it with the people you care about, your family, et cetera. But it is a scarlet letter that you'll be wearing from here on out. You will be required to register as a sex offender. People can look your name up and it will show at 123 Main Street, whatever your address is, there's a sex offender who lives right there. And that's stigmatic, appropriately so, but that's just something that you're gonna need to work through during the duration of your sentence in this case. And I need to make sure you understand that so that you don't tomorrow call Mr. Cohen or Ms. Merchant and say, wait a minute, I didn't know that was gonna happen. We need to undo this situation. You appreciate that there are these ongoing consequences. I may never see you again, but this sentence sticks with you for a number of years.
Yes, Your Honor.
Okay. Is there anything that you want to share with me? And you may be speaking to a different audience, but you and I are the ones having the conversation. But there may be things that you want people to hear about this situation. There may not be. Your lawyers were thorough and helped me understand from where you came, and in many ways, more importantly, where you've been going since this was brought to light.
May I have just a moment?
Sure.
If it's appropriate, I'd just like to apologize to my family, to my victims, to the court, to everyone involved.
Okay. Well, that's an important thing to say. My guess is, given how quickly you invested in treatment, that you've already said you're sorry to your family many times. This is the next phase of consequences flowing from what you were doing. All right, well, if you don't have any other questions, I do find there's a factual basis for your plea. And again, I recognize it's a plea to only seven images or videos, but the state has to draw the line somewhere. And my guess is if those poor GBI agents had to look at more. It could be an indictment with 1,000 images. It doesn't really change things, 1,000. If we're only one, your lawyers would have been able to negotiate something different than where we are today. Because while some people might walk away from here saying only probation, probation is the easy part of your sentence. It's all these other repercussions. That scarlet letter that I'm talking about, that you're going to need to wrestle with going forward. So I do find there's a factual basis in that your plea is knowing and voluntary. You understand what we've been talking about and that no one has forced you to enter this plea. I am not sentencing you pursuant to the Probation Options Management Act. And so what that means, unlike all my other cases, if there is any issue with probation, you forget to dot an I, that comes back to me, and you and I, Ms. Merchant, Mr. Cohn, Mr. Miller, will work through what the consequences are. And that's only because I want to make sure I know what's going on in your case. And I don't want probation to think, this isn't a biggie, we're not going to bug the judge about it. So I will see you if there are any issues. I don't know that there will be. I'm not putting it that way because I suspect there will be. I just want to make sure that I'm part of the conversation if there are any issues. You signed a whole bunch of documents and we will be making those a part of the record. The one document that you didn't sign is the actual indictment. And what we're going to do with your permission is electronically sign your name, indicating that you have pled guilty to all 7 counts of the indictment. Are you okay if we electronically sign for you?
Yes, Your Honor.
Ms. Merchant and Mr. Cohn, we'll get both your names on there.
Yes.
You okay with electronic signatures?
Yes, Judge, thank you.
And Mr. Miller, can we sign for you?
Yes, Your Honor.
All right. Do you have a firearms license?
No.
Okay. I'm going to sentence you consistent with this negotiated resolution to 10 years of probation. As to each count, they will all run concurrently with each other. So that's a total of 10 years. You will be subject to sex offender registration requirements. Those will extend beyond the 10 years. When your sentence is complete, your lawyers can petition to have sex offender conditions eliminated or relaxed so that maybe only some of them apply. But until your probation is over, it's not appropriate to seek that type of relief. Statutorily, that's part of your sentence until you successfully complete your sentence. The only condition that I will add beyond the many that you've already signed up for will be that you complete all 7 phases of the treatment that you've already begun. Sounds like you're 4 for 7, you've got 3 left. But until you complete those final 3 phases, you're going to need to continue to invest in that counseling. And once the counselor or therapist or medical professional can present to probation, yep, Mr. Newsom's done 7 out of 7, then you're going to need to be able to document for probation that you are continuing that counseling. Does that make sense?
It does.
And he does that at Medlin. I forgot to mention.
Medlin,
Yes.
okay.
I knew the court would know what that.
That was the initial, Miss Reiner worked for Medlin and then moved to her own practice, so.
Okay, Medlin it is. Officer Evans or Ms. Simpson, do we need to do anything additional? You give him reporting instructions in just a moment, Ms. Simpson, I know that, but other than me signing all of the different probation forms that he has signed, anything else we need to get on the record concerning his probation?
Nothing further.
Okay,
And the new name is New Foundations, Medlin.
New Foundations,
It's not,
okay.
yes, she moved to a different practice. She worked.
Meaning Dr. Reiner is at
Dr.
New
Reiner was
Foundation,
previously with Medlin,
but the counseling is happening where?
with Dr. Reiner at New Foundation.
Okay.
She was a
Was-
previous employee, left, started her own practice with another psychologist, and that's who he's been treated with.
Good, then I'll make it clearer on the final disposition. You'll need to complete the full course of counseling at New Foundations.
Perfect.
Mr. Miller, anything else?
Nothing further from the state, Your Honor.
Okay, Mr. Newsom, Ms. Simpson needs to give you some reporting instructions.
Thank you.
If you don't mind, I will speak with him out in the.
Yes, I'll let you do that. I'm just gonna get on the record now. Whatever date you're given to report to probation, your address is in Fulton County?
Yes.
So you'll be reporting to Fulton County Probation, which is a couple blocks from here on Memorial Drive. don't miss that first day.
Yes, sir.
Okay? All right, thank you.
Thank you,
Thank
Judge.
you,
May we
Judge.
be excused?
Yes, ma'am.
Thank you.
And thank you, Mr. Miller.
Yeah, thank you, Your Honor.
I'm just, I don't know how, I'm not comfortable doing this with you.
Hey, Ms. Cabrera.
Hello, Judge.
You look